exposed to contamination. We've argued strenuously against that. Briefs on that have all been submitted to the court, and we think that sometime in the next 6 months, the court is going to make a ruling on that. But we intend to continue to fight until the court tells us that they can't, for the idea that they have to come forward and they have to establish a pool of money to support a program where folks who want to participate on a voluntary basis can come in and be checked for these ailments in a way that routine health screenings do not cover. If any of you have spoken with doctors about potential PFAS exposure, you've probably found that they're not very well prepared to screen you for some of the types of things that you'd be concerned about here. And it's because it's an emerging contaminant, not very much is known, and your family doctor down the street just probably doesn't know that much. So in other cases, what's happened in other states with this and other pollutants is that folks have been able to go in and see a specialized doctor who's going to screen them for, screen their blood levels for levels of the contaminants and check them out for the things that we know are potentially linked to these substances so that you can have early detection and early treatment. That's one of the primary goals of the case, but as I said, it's a big hurdle in the state of Michigan, but we think that it's a fight worth having. The other component of it, which again seems unimportant by comparison, is the monetary damages. But we think that's a part of the case too. You've been inconvenienced, you've been put out of your homes, you've been unable to use your homes as you otherwise would, and everybody in here, I'm sure, is worried about their property values. And that's another thing that we're seeking, and that's something that frankly is a little bit more straightforward in the courts. And sometimes the only thing that these big defendants speak is the bottom line. They speak dollars and cents, and so that's really the only way that you can teach them a lesson is by hitting them for big damages in these cases. It's the only thing that makes them think twice before they put people at risk like this. It's really important to note that what is not a part of the class action is if any of you have been diagnosed with an illness or you suspect that you have one of the illnesses that may have been caused by this, that is not covered by the class action. There's a reason for that. Personal injuries generally are just considered by courts to be not appropriate for class actions. If you do have one of those injuries or illnesses, if you suspect that you have them, we recommend strongly that you should consult a lawyer and you should consider bringing your own individual case for those ailments before the statute of limitations expires. The statute of limitations might mean, I'll get to the questions as soon as I get through this. The statute of limitations is something that can completely cut off and bar and waive your claim if you wait too long to file it. And so depending on your particular circumstances, the statute of limitations could run as early as this summer or sometime later than that. We do anticipate filing some individual personal injury cases for some folks. We'd be happy to speak with anybody who has questions about that. But we do think it's important that if anybody here today suspects that they have one of those ailments, that they consult a lawyer and especially pay attention to that deadline for the statute of limitations. So we talked a little bit about the defendants. Who's responsible for what happened here? So there are 3 defendants in this case that we've sued. You're probably familiar in general with most of them, but Georgia Pacific Consumer Products LP is a subsidiary of Georgia Pacific, the big paper. Georgia Pacific Consumer Products LP is a successor to the James River entities that owned and operated the mill and the landfill for so long. They were using these products there, they were disposing of them in the landfill, and we believe that they did it negligently. Georgia Pacific LLC is the parent company of Georgia Pacific. It's owned by the Koch brothers, and they were responsible under an agreement with the state for safely closing the landfill. At the time that they closed the landfill, it was known to them and to the state that the landfill was having problems with affecting the groundwater. So it was abundantly important that they close this in a way that prevented water impacts, especially because they knew that the wells that the town draws its water from were so close to the landfill. We allege that they didn't do that. So those are the 2 Georgia Pacific entities. And then obviously everybody knows about 3M's role. It's been written about extensively, particularly after the discovery was made here. But they developed, produced, and sold these chemicals while they actively hid their dangers to humans and the environment. I'm sure a lot of you folks have read some of the crazy stuff that happened there. I mean, they had people, their own scientists quit saying that 3M was putting their own profits above the safety of people and the environment, calling these chemicals the most insidious pollutant since PCB. and talking about all the efforts that they had taken to sort of suppress it, to suppress knowledge of these things, including the fact that they were paying professors basically to bury bad literature. So we think that 3M, even though they're not the ones who directly put it in the water, the fact that they made these horrific chemicals and they suppressed their dangers, they should be held liable too, and so they're also a defendant in the case. They sold particularly a substance called Scotch Band, which is related to Scotch Guard, and that's a water and grease resistant coating that was used at the mill, and that's the primary avenue that this stuff got into the water. The Scotch Band was used at the mill. It went through a wastewater treatment process. The sludge from the wastewater treatment process went into the landfill, and where it was improperly lined, it was improperly stored, and it migrated predictably into the wells that the town drew its water from. So just some basics on how the case will progress. The judge, we had a couple of status conferences with the judge. Our case is pending in the Western District of Michigan. It's federal court. It's in front of Judge Janet Neff. And we've set up a schedule for the initial phases of the case. So the first thing that we're dealing with is this medical monitoring issue that we discussed. There's been, all the lawyers have written their briefs making their legal arguments to the court, and the defendants have made the argument that under no circumstances should any person in Michigan who's been exposed to toxic substances be able to seek medical monitoring. We disagree. We think that's wrong, and we're optimistic about our chances of prevailing on that. You never know what's going to happen in a lawsuit. There's no such thing as a sure thing in the law. But we, like I said, we think it's a fight worth raising, and we should know probably sometime in the next 6 months on that. Now, regardless of whether or not the court allows us to pursue medical monitoring, we're dealing with this issue right now at this stage of the case called fatal transport. Fatal transport means what happens to chemicals or pollutants once they're released into the environment. This is an important thing that we have to prove in this case. How did the chemicals get from point A to point B? While the evidence is incredibly strong in here, we can expect them to say, well, we don't really know, and some of it may have come from this plating facility, and some of it may have come from this car wash, and some of it came from over here. So we're working on the complex hydrogeological issues right now of proving that these contaminants went into that landfill, that they negligently operated and closed the landfill, and that they migrated into the town's water and exposed everybody. About a year from now, we're scheduled for what's called a voluntary facilitative mediation. This is something that the court orders, but it's an opportunity for both sides to sit down and discuss a possible settlement. Almost all class actions result in settlements and not jury trials because the risk to the defendant can be so big. But there are a lot of things that go into that, and this is a pretty unique case, so we don't know whether or not there's a realistic chance of there being an early settlement in this case. We don't. The evidence with 3M, they're fighting this thing all over the country, is that they've taken the opposite approach of being good corporate citizens and saying, boy, we made a mistake, we should really own up to this. They're fighting it tooth and nail. So there are reasons to believe that they are not going to be willing to consider entering into a settlement. But our job is to make the case compelling enough that they have to really take that seriously and to think about it. And so that's what we're going to be doing between now and a year from now. Yeah, absolutely. So class certification is the stage that will occur right around the same time as the mediation. And what class certification is the process where we go to the judge and ask the judge to certify our case as a class action, meaning the handful of folks in whose names who are all seated here tonight that we brought this case would be appointed by the court as the representatives of everybody who's affected that chooses not to opt out of the case. I doubt very much that most of you want to take time out of your jobs, out of your daily lives to go comply with discovery requests, sit for depositions, and those things. And so having the class certified would allow them to represent everyone without everybody having to come forward in their individual capacity and participate. In environmental cases, sometimes classes are certified and sometimes they are not. If the class isn't certified, everyone who's received a data sheet from us at a minimum will get a letter from us that says, look, the class wasn't certified. If you do want to participate at this point, now you would have to come forward on an individual basis to participate. But first, we're going to try to have the judge certify the class. And why that's important is because that gives us the largest possible number, the biggest, strongest group that we can bring into court and try and get an uneven playing field with these corporate defendants. So what can you do right now? You can ensure that you fill out a data sheet to be kept up to date on the progress of the case. These help us in figuring out the scope and variety of the impacts. They help us at the class certification stage. They help us show the defendant that this community isn't going to take this sitting down and isn't going to go away. That just because it's been over a year now, people haven't forgotten and they're not going to forget. So that helps us show that there's immense interest in this case. You can also provide us, whether through the data sheet or whether you want to call our office or just write us an email or just let one of us know with any useful information that you might have. If anybody happens to know something that was occurring in the mill that they think could be related to this, if they've got evidence that isn't in the public sphere that they think we should know about, we'd love to have that information. And then, as I discussed, consider retaining an attorney to advance any personal injury or health claim that you might have that you believe is related to the PFAS contamination. Because again, we want to make sure everybody is aware of their rights. You don't want to slumber on your rights, as they call it, and give up what rights you might have by waiting too long. Well, so any attorney who's going to take a personal injury case, almost exclusively will do it on a contingency basis. So we are prosecuting this case on a contingent basis. We're not asking for any money from anybody. We're covering all the costs, which are very significant when you start talking about the blood testing and the expert witnesses, just the cost of litigation. I mean, even the infrastructure required to process the 100,000 pages of documents they produced, and I'm betting it's not 2% of what we'll have. They're very significant costs. We're not asking anybody for a penny from that. And so anybody who would take your individual case, I would advise you that you should never hire a personal injury lawyer who doesn't take your case on contingency. If they want money from you, it's a bad sign. So with that, we'll open up to questions. If there are any questions that folks want to ask that they think are sort of applicable to the group, we'll take those now. And then if there's anything that just pertains to your own particular situation, the three of us will be around if you want to, just come up and talk to us. We're happy to answer those questions.
I live in Cooper Township and we're on well water. We have not had our wells tested.
Okay, so that brings up a couple of issues that we should talk about. The class, as it's defined right now, does not include anyone who is on well water. It only includes people who receive their water from Parchment's municipal water system. A lot of folks have had their wells tested and found out that they do have varying levels of contamination. But in a class action, you have to have, the court requires that everyone is what's called similarly situated. So everyone has to be subject to the same circumstances, and it makes it very difficult for us to include folks who are on private well water. I would encourage you to speak with somebody if you do believe that your well has been contaminated, and we've got some good resources for you. If you want to privately have your water tested, I'd be happy to speak with you about that after we get done in the group. Yes?
You talked about that federal court judge, Janet Jeff.
Neff.
Thank you.
Yes.
Okay, you say we're not included out in Cooper. I live in Indiana.
No, anyone in Cooper who's on Parchment's municipal water system or would be included.
My home abuts to the river. My well is within 300 feet of that river. You're saying that there's no connection?
No, I'm not saying that at all. I'm not saying that at all. I'm saying for purposes of our case, we have to have one cohesive group, and it's anybody who is on the municipal water. If your circumstances might be different if you have a private well, and that's something we'd be happy to talk to you about, but it wouldn't be included in this case.
I could say this, if you have a private well and you haven't had it tested, in my opinion, you should have that water tested, even if it's not related to litigation, you want to ensure your own personal safety.
Correct.
Okay. Everybody talks about the contamination. Is it just ingesting the liquid that affects you, or just bathing? Because I personally have owned the place for 10 years and have never drank that water for various reasons.
So we're not doctors, we're not scientists. If we were that smart, we wouldn't have to be lawyers. But the primary means of exposure that a lot of folks are concerned about is through ingesting it. I cannot tell you it's completely safe to bathe in. I can't tell you one way or another, but the primary thing that we know, I mean, right, if bathing in it were bad, drinking in it is a hell of a lot worse.
Okay.
So
Let me introduce myself. I'm Steve Cox.
I see.
I'm a licensed builder and a licensed building inspector by the state. I've lived on the river for 10 years. I'm a lifetime fisherman. That I stand in that river and I fish anywhere from Comstock River all the way to South Haven in various stages of this river. I'm in more contact with this river and know more about this fishers off and waded in shit.
What way? You're speaking my language,
You know,
I understand.
they're destroying a whole fishery. This isn't just these people here.
I understand.
If you look at the fishing industry, and I personally spend way too much money on my hobby.
So you're, just so you know, you're speaking to a fellow afflicted
Michigan
fisherman.
is a big part of this economy, so it's not just the homeowners that this is affecting.
I'm not saying it is, okay, and we aren't purporting to solve the entirety of this problem. But our case, we're private attorneys who have been retained to bring a particular case, and that case is the contamination of the water as it relates to people's drinking water in Parchment and Cooper Township. Now, I can tell you as a fellow conservationist and someone who spent 65 days on the river this year, I share your concerns, but it's not something that we can lump in with this case. It would detract from the case and it would hurt our chances in this pursuit. So I share your concerns, but.
Well, actually, I don't sue. I've had more reasons to sue, but I'll let you judge. My wife in the last 5 years went through 4 different surgeries
Sorry to hear it.
for ovarian cancer. Complications, surgery, complications, surgeries.
Well, in that case, I would certainly advise you to have a.
I personally have a medical history with this too, so our connection to that river, I am really concerned. And actually, when they were testing along the river, they wanted to test part of my property for the PCBs.
Okay.
I made them test the whole river.
So, I do want to try to focus on things that are germane to the whole group, but I'd be happy to talk with you some more. We've got contacts in the state. If you want to try to have MDHHS come out and test your well, as opposed to a private company, I can share that
Why don't you
information.
talk to us afterwards? We
Yeah,
have a lot of
yeah.
questions.
Quick way to tell everybody that isn't interested in the class, if this case is decided in a particular manner, would it be suited for reference for other cases? So they wouldn't have the whole laborious process to go through? They can be like, hey, just cite that case.
It's,
We're not
so,
part of that class.
like all things in the law, the answer is kind of. It's possible. Yeah, there could be benefits from it, but it's a complicated answer.
But if you have a different issue that's not part of the class, you have to be concerned about the statute of limitations expiring or running. So if you have an issue where you don't think you're part of the class, you need to speak with a lawyer sooner rather than later. That would be our advice, and we're happy to have those conversations with you, but it's more of an individual issue. Let's do that afterwards.
Yes.
So I don't live or own property in Parchment, but I've worked here for 20 years and drink the water, stuff like that. Is that am still eligible for any of these?
So right now, the way the class is defined, it only includes folks who live in homes that were serviced by the water system. It is possible at some point that the class definition would change, but because when you start adding in folks who either just work there or who dine in the restaurants, it becomes very hard to keep a cohesive class. And so as of right now, based on that, you would not be included in the
Not
class.
even, if you do get the medical monitoring, then, so not even that either.
Like I said, it would depend on how the class is defined at that time, and that's something that's still not totally determined, but not as it's currently constituted.
How many people here, if you raise your hand, are not users of the Parchment water system?
Well, see, I'm a user at work, not at home.
Users, and you live there. I guess I didn't state that question. There's a lot of people here. Are you folks people who just come into Parchment and you don't live there?
I have well water.
Okay.
But our wells have been contaminated by the PFAS.
Okay, you know what, let me break it down a little bit. How many people are on well water? Raise your hands. How many of the well water people have had their well water tested?
My last response from most people is, there is no test.
Oh, there is.
So no, the state's conducted fairly extensive testing on private wells.
Asked about it, and there's no definitive test.
So anybody who's got a private well, we would be happy to speak with you about it after work. Those issues are not part of the class action, but we'd be happy to speak with you about that after. Yes?
What if you own property in Parchment? A lot of them.
So,
Part of the class action, right?
as of right now, the class is defined as anyone who resides in a home that's serviced by it. So if you do reside in a home that's serviced by it, yes, you would be included.
on the city water, raised a family. Those kids are now adults and have moved away. Would they be part of this?
If they were living in, so, I wanna be careful to come back to the way the class is defined currently. Class is currently defined as folks who lived in the home on the date that the contamination was discovered. One of the things that we're still grappling with is the duration, right, of how long that this has happened. And that's something that we don't have clear answers that I can discuss right now. So it's possible that that class definition would change, so the best answer I can give you is I'm not sure.
Okay.
What date was that? When it was discovered?
You know, I don't have the exact date in front of me. It was July of last year.
They knew about it.
I'm sorry, of 17, correct. Yes.
The house was bought in 1963. The kids were raised on all this type of water. We went on Cooper Township that forced us into water from Cooper Township, and we still were affiliated. Now this, I can't believe that these children, which were having problems with the kids, I'm the stepmother. And I'm having problems myself now. It's unreal, during that time from 1963 to the present, and these children were raised in that house. It doesn't make sense that they wouldn't be acceptable for having some problems.
I'm not saying that they're not. I'm not saying that at all. What I'm saying is we've defined the class in a way that it meets the criteria we believe to be certified as a class action right now. And that class definition may change as we get a better sense of exactly what happened and when. But we don't know that right now, so we can't speculate.
But it takes years.
I'm sorry?
It takes years for this to arise in different human beings.
It does. It absolutely does. Look, let me assure you, we want to get the maximum amount of relief for the maximum amount of affected people, but there are certain procedures that we have to follow because this is a federal lawsuit. So, exactly. So,
Get the ball started for the other.
exactly. And so we want to include as many people as we possibly can. That it's in our interest, it's in your interest. We want to do the right thing. We want to make sure the most possible people get the attention that they deserve. But we have to meet certain requirements in the lawsuit. So.
And so do class definitions change as the lawsuit progresses, as new information comes to light?
They often do. So that's one of the, as we go through the process of getting documents from the defendants and through our investigation, in what's called discovery, it is possible that the class definition will change. And if we've got solid evidence that the contaminants entered the drinking water at a certain time, we can open up that class definition.
But you do have to understand that as it's currently, it may not change, and there are concerns about the statute of limitations. If you have real concerns about people that aren't included in the class as it's defined now, you need to talk to us or talk to a lawyer sooner rather than later, because that statute of limitations can sometimes run.
So if they wanted to change to the people who live in the area that has the parking water, well, my husband and I live up off of Mazel, where the city tells you that city water is only parking good. Why did we get a letter?
So it may just be that the database that we sent the letters to was not perfectly calibrated to the water system. Well, you're certainly welcome to stay, but if you don't have an interest in the water system.
Where you fill the paperwork out now.
I'm sorry?
I got some stuff going on medically.
Okay, and we'd be happy to talk with you about that, but at least by virtue of the class, it wouldn't be included.
So my data doesn't matter?
No, that's not at all true. It's just,
Well, one of the things you guys have to understand is we're here somewhat in a fact gathering fashion. You know, so when we hear things like that, or the well water, or the kids who weren't here before, we wanna hear those things.
Is it possible that you folks, been having conversations about thyroid,
I'm sorry.
and the complication is the body won't absorb the medication. So now the whole endocrine system is affected, as are the rest of the world. Dr. Nettleton from our health department, the director, sent me on that wild goose chase to California to
as I was denied 2 doctor orders by the hospital to be tested for PFAS. As I tried to go through them and through everyone, they needed the code so that I could be tested. When I got back over to just get the code, she told me, yeah, Michigan's have different places in it. Will you tell me, and will you inform me how to get a hold of the code or to get that done? Is that something you folks?
I'd be happy to discuss that with you. I want it, for anybody who's got illness or injury issues, we'd prefer to take those outside of the group setting. We don't want to share those too publicly. But yeah, I've got some information that I can share with you. We've got a laboratory that we've used privately to have the tests done, and I'd be happy to share that with you, for sure.
My father worked at the mill for 20 years before they started tearing it down. And my sister has everything on the list. She lives on G Avenue, right down there, on Thomas Street, I'm sorry. You're saying that if she's been told she has all this stuff going on before this class action thing started, that she wouldn't be included?
No, that's not what we're saying. And again, we want to reiterate one more time that if anybody believes that they've actually gotten any of these illnesses, that they should seek independent legal counsel. They should talk to a lawyer, because this case does not cover those personal injuries or illnesses. It doesn't automatically cover them. They don't fit into a class action, so it's not part of the case.
So she should hire an outside lawyer, because she would be included in the class action?
She would not automatically be included in the class action.
Okay.
But by those illnesses and injuries would not. If she's otherwise a class member, she would be part of it for the medical monitoring and for the property damage. Yes?
Is there a specific test that a person's engaged to see if their body has been contaminated by PFAS?
Yes. Yeah. There are blood serum tests that you could have conducted for PFOA, PFOS, total PFAS chemicals, because there are thousands of them, but the two main ones, and the two main ones that were in the water system were PFOA and PFOS. Most folks have a hard time getting their insurance to cover that, and it can be costly, but there are tests that, another thing that we want to discuss is that the state of Michigan, I'm sure a lot of you have heard rumblings about this, is talking about doing health assessments. I spoke with a toxicologist at the Department of Health and Human Services today. She was not able to give me any concrete details on that, other than to say that it is going to be tied in with a national study that the state of Michigan just got $1 million grant to participate in, and that they are going to have some Parchment-specific findings, but she couldn't tell me when they might start recruiting folks for that study, when they might open up details of it, and when that might happen. So one avenue might be to wait and see, but we don't know when that's going to be. That the state might open that up.
Hey folks, you know what I'd like to do? I'm sure some of you want to get moving along. If you have a question that's individual to your circumstances that you don't necessarily think would be beneficial to the group, myself and Matt will be out there.
Yeah.
We'll be out there to take those individual questions.
Yes.
Yeah, so the Wolverine Worldwide case has no precedent, is that what you're saying?
No, so
as well as West Virginia, where it all started?
So the C8 litigation in West Virginia provides a lot of the scientific evidence because of the science panel that was there that we rely on in this litigation. And so, so the West Virginia case provides a lot of helpful, useful scientific background in this case, and the federal litigation, so there's both state and federal litigation involving the Kent County Wolverine sites, and the federal cases are all pending before the same judge that we have, Judge Neff. And some of the same defense lawyers are representing Wolverine and Georgia Pacific. So none of this happens in a vacuum. This judge has got all of the federal PFAS litigation in the state of Michigan right now. She's going to be very well informed on this. She's taking it very seriously, we believe. And so there certainly is some crossover in that the judge is going to be very well educated on these substances and their effects. And some of the legal issues are going to be the same. So there's going to be some crossover, but there's not a formal consolidation of the cases.
I just want to add, this guy right here just had a question about the testing.
Yeah.
When I went to Bronson, they would not even like subscribe or whatever, like the test. So even if you wanted to take the test, you really can't, like, your doctor won't.
And Chrissy's one of our named plaintiffs in the case, so we arranged to have the named plaintiff's test conducted and sent to a specific laboratory in California, but even having the blood drawn down in Bronson was
They won't do it.
remarkably difficult.
Yeah, and it's like $1,200 if you want to have it tested personally.
I don't care.
Well, first of all, I
Just
just
let
want
you
to
know.
say
Just
that
let you
there is a lot of movement being done with the state with the blood serum testing, with the ATSCR, and they're hoping to somewhat work in conjunction, but they have to write up the study, and it has to be done down to the letter of how they're going to conduct it and making sure that it's uniform. And they're also following a study that was done in a similar location in Plainfield Township. So I just want everyone to know that they will test your blood and they want you to be involved, and they're actually asking questions on how to, have residents become interested, and how do we get people engaged and volunteer to have their blood taken. So it's great to hear that there are people that are really wanting to have that done, because the state is very interested in collecting that data. And what that means from, we don't really know. I mean, that's kind of getting the ball rolling on finding out, tracking your blood levels and your health problems for future, outcomes for other communities. So I just want people to know that's not something that's a pipe dream, that's not gonna happen.
Yeah, we just don't have details on it yet.
Right.
And I would encourage everybody that has that opportunity, that even if you don't see the immediate benefit to it, to consider participating in that. I know in the Kent County instance, they've had some participation difficulties getting enough people to participate, but it's worth knowing, and it helps getting a better understanding of the entire picture for everybody.
I did have an actual question for you.
Okay, yeah.
So this is something that people are gonna wanna know, for people that have lived in their homes 4 or 5 years versus our neighbors lived in our homes 65 years. So if there is a settlement, in this case, that money is going to be divvied up based on the length of residency. Do you have any sort of ideas on that?
So there are a lot of different ways to do it. I mean, I could tell you how it happens in other cases, but it's just too early to know in this case. So, if the evidence shows that the contamination has been in the water for one period of time versus another, that's a variable that could change things. It's too early to say. I mean, we've had no settlement discussions. We've had no indication from either side, either group of defendants, that there's going to be any real interest in pursuing settlement. For all we know, we may have to take this thing to trial, and we're prepared to do that. But what I can tell you in general is that when we do reach settlements, we make sure to try to include every equitable circumstance to make sure that everyone's treated fairly depending on their various circumstances.
So you're gonna have to prove that this water has been contaminated for X amount of time, otherwise we're all entitled to the same, they're gonna argue, well, maybe this just happened 6 months before they found out.
They might say it happened the day before.
Right.
I mean, I wouldn't be
Right.
surprised.
So you're, just so everyone knows, you guys are fighting, we're on the same team here.
Yeah,
So-
absolutely. And I appreciate you saying that. Yes?
That's a question. I understand that Attorney General Nessel has hired 3 firms to represent the state in class action suit.
That's right.
How does that differ from your class action?
So the state will be pursuing litigation for the state's own costs, largely remediation costs of these actual contamination sites, but they're not going to be seeking damages for individual property owners, renters, citizens. So, in Minnesota, there was an $850 million settlement with the Minnesota Attorney General. That was just money that went to the state to help remediate the contamination at particular locations, but it doesn't help make people whole who have been individually harmed.
There's some talk of statute of limitations. With this health stuff, it takes years and years to run. So if somebody has an issue 5 years from now, they're just out of luck, is that the case?
No, not necessarily. So there's some very difficult case law in the state of Michigan on statute of limitations, but generally speaking, if you have not yet developed an injury or an illness, then the statute of limitations can't run on it yet. So there's a version in Michigan of what's called the discovery rule. If you discover the illness, then your statute of limitations starts running then. That's very, very general. If anyone has specific questions about their own situation, I encourage you to speak with me or another lawyer. But no, it doesn't mean that if something comes up down the road that you're just totally out of
So
luck.
these people are talking about their children being raised in these homes, that would apply to them in the future.
Yeah, in general, yes. In general. Yes.
Is this just for the homeowner and the people that are actually registered at that address, or would it include somebody that had been a guest in that home at the time eating there, showering there.
So I hate to give
What do
you,
like?
I hate to give you a really lawyerly answer, but the way that the case is defined, it's all residents of those homes, so that would come down to what constitutes a resident. So if it's somebody who was just spending the night there a couple of times, probably not. But if it's somebody who was sort of a long-term guest or lodger there, I would say that probably would include them. But it's, we're sort of right on the border of, you know, who
Well,
would
you're
be.
like a fiance, you know how often they stay over.
Well, so I guess in that situation, it would be up to the individual to establish that they were a resident, and, you know, all of those things would go towards that. Yes?
Okay, on the other side, what happens if you got a conflict of interest?
In what way?
I live in Parchment, but I worked at the mill.
Sure. That doesn't.
I worked with the stuff dealer.
You did.
Yes.
You did.
I touched that food processing stuff, okay? Now, like she was saying, you know, the fiance, you know, I worked with the stuff.
So I'd be very interested in speaking with you about that in general.
How can I work, you know.
But from a conflict, so there might be reasons that you might want to consider that your own suit, but from a conflict of interest or perspective, that's not a problem, right? So people are involved in class actions every day against their current employers, let alone former employers.
No, I would.
Unless you own James River, maybe.
In which case, we'd like to ask you to go.
I got my pension, oh no.
Understood. Yeah.
So when this first came out, they said that it had been in the water for 40+ years. Is there just not proof of that? Is that?
I haven't actually seen that credibly alleged. It's possible that it was because that would track the timeline of the use of the chemicals. We're expecting to have quite a bit more background on the length of time from our hydrogeologists as they get more into how it got into the water table, the particular migration and how long it took. And there are ways by looking at the chemical properties of this stuff that they can figure it out, at least within a pretty reasonable range. But I'm not sure where you read that, but I haven't seen anything that would back that up right now.
Well, one time it was on the.
Okay, yeah, I'll have to look at that. I've not seen somebody allege that, but if somebody said that and they said it credibly, then it's based on something that we haven't seen. Anybody else down this way? Yeah.
If you are able at some point to prove that this went on for a certain amount of time.
How long does PFAS stay in someone's system?
So if there's a class certified.
I can't hear. I'm the interpreter and I can't hear. Your question again, please?
I was asking if we were able to determine at some point the length of time that the contamination was occurring for, and the class is then expanded because of that, will we be notified?
So if a class is certified under any circumstances, everyone who's a member of the class will receive notice in the mail. We'd also be publishing notice.
Even if they're no longer a current resident?
So if they're not in the class area, we'll do our best to do a supplemental